Good afternoon, everyone. Thanks for coming along to this week's 3CL Travers Smith 3CL Travers Smith Lunchtime Seminar. Delighted to introduce our speaker. Some of you may know already, not least because Professor Ahern was a visitor to the faculty last year. Now she's come back to speak to us. So Professor Deirdre Ahern is an associate professor in the School of Law at Trinity College, Dublin in Ireland, and also an alumnus LLM alumnus of this university. Professor Ahern's primary research areas are corporate law, comparative corporate law, corporate governance and commercial law. Her research agenda engages not just with the law itself, but also with the societal expectations of companies and their directors, including the ethical challenges presented by globalisation. And she's written extensively on the theoretical framework surrounding the duties of company directors. And indeed, I think the work she's speaking on today allies quite nicely with that general line of thought. Professor Ahern's book, Director's Duties, Law and Practice, which was published in 2009, was shortlisted for the Kevin Boyle Prize, which is basically the prize for the best law book in Ireland. So her work is very highly thought of, and she's published in a number of highly respected outlets, both nationally and internationally. So Professor Ahern's paper today is titled Conceptualising Overreach in the English Corporate Opportunities Doctrine. I'll hand over to Deirdre.
Thank you very much, Mark. Good afternoon, everybody. I'd like to say thanks so much to the 3CL Centre and for inviting me here as part of the Travers Smith seminar series, and for the very warm welcome I've received from everybody here. It's always a delight to come back to Cambridge and to the law faculty. So I'm going to talk to you today about a particular part of company law, common law doctrine, known as the Corporate Opportunities Doctrine, as it applies in English law. And I've got a particular theoretical angle that I'd like to get across to you today. So just in terms of the structure of my presentation, I'm going to start out with just outlining the nature of corporate opportunities, what's involved, and then moving on to look at the kind of polarisation of two competing judicial approaches that are in evidence. The meat of my paper, I suppose, is concerned with a phenomenon that I identify as overreach. So I'm providing that descriptive taxonomy for a particular phenomenon in how the English Corporate Opportunities Doctrine goes beyond the immediate protective needs of the individual company and overreaches, if you like. I then go on to look at potential macro-level normative justifications for this. After looking at some of the standard justifications that tend to be there in the case law and the literature, I attempt to expand upon those and provide a more societal social cohesion thesis, if you like, for that. And I wrap up then with some conclusions. So I think in a way we're concerned with today something called human greed, which I think is something we're all familiar with, our natural human tendencies towards acquisition. So as humans, we're programmed, at least by society, to want more money, more property, more of everything, really, unless we've embraced minimalism, which is not something everyone has done today. But society is tending to tell us that we always want more. And in a way, what I'm looking at today is how the law has sought to place boundaries on company directors in terms of what they can do in terms of acquiring more at a personal level, while they're supposed to be engaged with focusing in on profit maximisation for the company. And that's what the Corporate Opportunities Doctrine is centred around. So the nature of the Corporate Opportunities Doctrine, well, I suppose we begin at the beginning, which is that directors in a company are exercising delegated power from the shareholder body. In doing so, they're given a free rein to exercise their discretion in order to engage in profit maximisation. And it's expected that they will engage in risk-taking. It's expected that they will look for new opportunities. It's expected that they will see if there's an opportunity for the company to expand or to diversify. But in doing so, there's always the fear that they may think about actually looking out for an opportunity for themselves. So they may be in discussions, for example, in relation to an investment property and they think, well, what if I was to invest in that myself? That would be a great opportunity. I could invest in this and resell it later on, and I would make a personal profit. Why would I want to give that to the company? You know, they have enough going for them already, and they won't miss it. Or something like that. They will always, you know, humans will always rationalise why they should do something that benefits themselves. Or maybe they are engaged in negotiations about a consultancy contract. The company might be thinking about providing services to somebody else in a consultancy way, and then they think, gosh, I could actually just do that myself and cut the company out of the equation, or I could set up my own company and maybe divert that opportunity to my own company, and again, I will make more for myself, and the company will not be involved in it. So this fits into what we call agency theory as well, which directors are agents. They are part of a principal-agent relationship with the company, and agency theory tends to characterise agents in a probably not a very favourable light, but it says that they are self-interested maximisers and welfare maximisers. So no holds barred there. They are saying that, you know, humans, if left unchecked, may act in a way which is going to benefit themselves, and that's why the regulatory stance that the law takes needs to maybe create some kind of a check on that natural tendency towards human acquisition. Thinking about how the law approaches it, really it can be boiled down to a fairly general bifurcated approach. We have two different possibilities that are evident in the common law world. On the one hand, we have a very strict approach which says that if you come across an opportunity as a director, you should immediately disclose it to the company, and it's up to the company to decide whether it should be rejected or not. And it's what I would call a hardline approach. It's an absolutist approach, which is based on a rule which more or less says you must disclose. You do not make the decision yourself as to whether or not the company would be interested in it. And it's more about the rule than anything else. On the other hand, the alternative approach that's evident, say, in the US and Canada, is a more holistic approach, which looks more generally at saying, well, what about evaluating the particular opportunity that's before us? Should we say that it really is something that the company is interested in, or should we say that there's no particular interest of the company in it, and the company would never have taken up this opportunity, so the director would be free to go ahead and doesn't have to notify to the company at all, that they can make their own analysis of it, and if they're correct, then they won't be faulted for having failed to disclose it. What I'm interested in particularly today is the strict or hardline approach, because that's what has dominated English law, and I'd like to be able to focus in on trying to explain that. There's been a lot of explanations given for the alternative, more expansive approach, but there's been less focus in on trying to explain why a strict approach might have a benefit and what are those benefits. But first of all, maybe I'll just take you to looking at a little bit at the cases that establish that principle in English law. So it begins way back in 1726 with the case of Keach and Sandford, which later became known as the rule in Keach and Sandford, where you had a trustee and there was an infant beneficiary. And if you're an infant, as you probably know from your days of contract law, you're not allowed to enter into contracts if you're a minor, unless there are for certain necessities. But here, the trustee renewed a lease in favour of the infant beneficiary because the infant would have not been able to do so, and they just wanted to make sure that they would get the benefit of a lease. So there was no element of impropriety whatsoever, yet the Lord Chancellor said that that was irrelevant, that if there was any whiff of a potential of conflict of interest, then it was not something that you should do, that it shouldn't have renewed in their own name. So that kind of gave rise to a strict and unbending approach that then later became applied not just to conflicts of interest generally, but also to the specific territory of corporate opportunities. The next case I'd like to mention, it's one I think if you have studied in a common law context, I think you'd be very familiar with. It's one of those very familiar chestnuts of company law, Regal Hastings Limited and Gulliver in 1942. So this, I suppose, is the locus classicus in relation to the English Corporate Opportunities Doctrine. Here, in this case, I mean, the facts were quite involved, but when we boil it down, essentially what happened was the directors of the company decided to subscribe for some shares in the company in order to ensure that it had sufficient capitalization so as that the company could then acquire 2 cinemas. So really they put some money into the company so that it would have the ability to take up an opportunity. Later, the company was sold by way of a share sale, and the new owners sued the directors, saying that they were in breach of the duty to avoid conflicts of interest, and they successfully managed to recover the windfall benefit that the directors had got in relation to their shares when the shares were sold. So this case, it was one of those cases which showed that the English Corporate Opportunities Doctrine the law is divorced from a morality principle. So we're not interested in saying, is there moral blame here? There clearly isn't. In both Keach and Sanford and Regal Hastings, it was clear that the directors were acting unquestionably in the interests of the party they represented. They were acting in good faith. And really, it was just a question of that they happened to be a fiduciary, and in Regal Hastings, a director. Lord Russell in Regal Hastings mentioned just by the by, said, well, you could have solved it all if you had got permission from the shareholders or shareholder approval. Then you would have been able to rectify that breach either in advance or after the fact. So that, I think, that sort of harked onto a later focusing on disclosure as being the only answer in the English Corporate Opportunities Doctrine, that you had to seek approval and the informed consent of the shareholder body. Looking at that now in a little bit more detail, what you have in the English doctrinal canon is a bifurcation between the dominant strict approach and a few outlier cases which seem to kind of flirt briefly with the more expansive approach that is what's known as the maturing business approach in shorthand, which was influenced by, I suppose, Delaware and Canada. So you see, for example, in the Island Export Finance case, in that case, the company had been supplying post boxes to the Cameroons. Later, it was no longer interested in that market at all, so that when a director decided to enter a similar market, the judge in that case said, well, there was no maturing business opportunity involved. The company wasn't negotiating for something like this and was no longer interested in the area. Therefore, the director was free to actually exploit the opportunity, and there was no question of a conflict of interest. So that sort of much more holistic emphasis on whether the opportunity could be said to be something the company was interested in is absent in the stricter approach. And those cases on the right-hand side there, under the rubric of expansive, as I say, I characterise them as outlier first instance cases, which later were hit on the head when it came in with Buller and Buller in the Court of Appeal in 2003, and later kind of cemented by the O'Donnell and Shanahan decision, again of the Court of Appeal in 2009. Just to show you, in case you're not so familiar with those cases, what's involved in terms of how strictly the Corporate Opportunities Doctrine works in English law. In Buller and Buller, a director encountered an opportunity on his day off. He found out there was a property investment available. The property happened to be next door to the company's premises, but the company had already resolved that it didn't want to invest further in property for the time being. The director and another director got legal advice and were told it was fine to go ahead. They did so. The company then sued them. And what did the Court of Appeal say? Well, they applied an unrelentingly strict Regal Hastings application, which said you should have presented it to the company, and it's irrelevant that the company, had said it wasn't involved in that area. You should have presented it to the company, and you didn't. Then we had O'Donnell and Shanahan, again, a similar sort of situation. The directors of the company was engaged in investment of properties on behalf of clients. Here, the client didn't actually take up the investment opportunity. It was offered to 2 of the 3 directors and shareholders. They decided to go ahead and invest in this particular area house in London. They didn't present it to the company. Essentially, it would have been them and one other director shareholder, because they knew that the company didn't have additional money to put in. The 3rd director shareholder didn't have money to add in. So they just decided, we won't bother putting it on the table because the company can't take it. But in these cases, the emphasis is always on, you can't make that decision yourself. You have to present it to the company for rejection or approval. And if you don't, there will be almost ipso facto a breach of duty of conflict of interest, and you will be obliged to account for the profits. So this is the very strict and unbending approach that needs to be explained in some way. So I do so in using the concept of overreach, which I'll come to in a moment. But I'd just like to emphasize how disclosure has, in a way, upended the question of conflict of interest, in that it's no longer focused in as a question in the courts. You now see the question as being, did you seek disclosure? If not, it's open shut case. There's a conflict of interest. And this is kind of brought out here in this quote from Lord Justice Rimmer in O'Donnell and Shanahan, where he's saying, it may be that the company would have had no interest in this particular type of opportunity, but it's no answer for you to say that. It's up to you to actually present it to the company so they make the decision to consider and to reject it if they want. So it's irrelevant that they may have had no interest in that particular area. What I would call it is this is a disclose or else mantra, which has now appeared in the case law, and there's no answer to that. If you haven't disclosed, it's irrelevant that you could say the company wasn't having some kind of pseudo proprietorial interest in the opportunity. So how do we go on to explain that? Well, I do so beginning with sort of identifying the phenomenon of overreach. So my starting point here is an acceptance of the doctrinal status quo. I'm not going to argue with whether I like it or not. It's pretty entrenched over almost 3 centuries at this point. So I'd like to just kind of conceptualize it first using the concept of overreach, and then look at kind of normatively explaining it. So I do so here using a pyramid. The bottom part here, I have what are called proximate cases. So this is the English Corporate Opportunities Doctrine and its application. I see it as having 2 distinct aspects. On the bottom part, the proximate cases are cases where there clearly is a direct conflict and there is the potential for harm or loss to the company. These would be the direct competition cases where a director is muscling in. Perhaps there are negotiations already on the table with the company and somebody else, and then the director just moves it off and takes it privately. So there's a clear conflict of interest and there's clear loss to the company. On the other hand, what I term overreach cases are cases where it's difficult to say that there's a direct harm to the company. And I say that in applying a strict corporate opportunities doctrine, it's over-inclusive in a way. It overreaches and goes beyond the proximate needs of the company because there is no direct loss there. And if you like, it provides a windfall benefit to the company as well. So you can break that down a little bit more based on the case law that's in evidence. And I would just make it into 2 different headings here. The first one on the left there, the company is lacking functional capacity. So it may not have the financial ability to take up the opportunity. So for example, the case we just looked at of O'Donnell and Shanahan, where they wouldn't have had the money to take it up, but still a conflict of interest was found. Or there may be some sort of practical limitations operational reasons why it couldn't do so. So these cases, you will see mentioned in the literature under the heading of the impossibility argument. So the impossibility argument, scholars who feel strongly against the English approach would say, is it fair that it would have been impossible for the company to take it up, yet we're still saying there's a breach of duty and that the company can recover gains based on that. The second heading there is that the company's interest can't necessarily be assumed. For example, there may be no a maturing business opportunity, the company wasn't directly involved in negotiating something, or it isn't obviously within the company's existing or future line of business. Now, I do appreciate that idea of existing or future line of business one, that can be disputed because obviously it's open to companies to change markets, etc. But for this present purposes, I'm just trying to provide a sort of a taxonomical structure, and I think that's fair to say that you can say, well, it can't be assumed, although it's obviously contestable maybe, that a company may have an interest in a new market that it hasn't been in before. Okay, I'd like to develop that a little bit more, but first, it is interesting to note that when directors' duties were codified in English law in terms of providing a statutory statement in the Companies Act 2006, the Parliament chose to give, if you like, a legislative cue as to what it thought about this phenomenon of overreach. And it sort of nudges judges to continue to provide the same answer to this phenomenon, rather than taking the more expansive approaches, the Delaware or the Canadian approach of the maturing business opportunity, fact-intensive analysis approach. We see that in section 1752 there, where it's clearly stated that it's immaterial whether the company could take advantage of the property, information, or opportunity. So that's quite clearly, as I said, a cue being given to the courts. Very often in a statutory context, the legislation will hold back and say nothing, and allow the courts to develop their own approach over time and leave room to do so. But in this instance, it has entrenched what is already a well-entrenched judicial approach. It's now made it more difficult for judicial activism to override that. You might have thought before then that if it came to the Supreme Court, they could change things, but that does add to the entrenched status of overreach and indeed the English Corporate Opportunities Doctrine as a whole. The other point to note is the peculiarities of the enforcement right of the company, that usually you will find that the appropriate remedy that's sought is not going to be equitable compensation, which is loss dependent, but rather the choice that will be made will be to apply for an account of profits, which recovers gains made by a director and is not loss dependent. So crucially, the English Corporate Opportunities Doctrine, when combined with this equitable remedy of account of profits, gives rise to a possibility of windfall benefit to companies. So they can make money by suing directors, even where they would have had no intention of going into that area or no ability to do so. There's almost a windfall to be gained from the fact that the director did not seek approval before going ahead, and that that's a quibble that many would have, but that is the reality there. That there is this overreach generates. It's a covert, I suppose, welfare and wealth enhancement mechanism that's there as well for companies, and that also adds to the overreach phenomenon of the duty, the actual consequences in terms of remedial benefit. Moving then, I suppose, to look at the central part of my paper, I'm interested in exploring the normative justifications for this identified phenomenon of overreach, whereby the English Corporate Opportunities Doctrine goes beyond the immediate protective needs of the individual company. First of all, I'm going to look at the micro-level justifications within the immediate director-company relationship at hand in an individual case. And then I'll move on to look at something which I think has been underexplored in the literature, which is the question of, are there broader macro-level justifications at a societal level at play that perhaps might help us to explain what could otherwise just be written off as a very rigid and unhelpful rule. Perhaps there is something to be said for this rigid and well-entrenched rule, even if it may be somewhat unpopular to say so. The first thing I'd just like to rule out is the question of a link with morality. I think it's quite clear when we look at overreach that there isn't a direct link with morality in how the English Corporate Opportunities Doctrine works in overreach cases. The very fact of overreach says that there is no obvious claim morally by the company to the opportunity, yet the law protects that company and provides the means of a windfall benefit. So we're clearly not linking it to a direct morality or ethical link in overreach cases. Yes, in proximate cases, there is one, but morality is not the key issue. So law and morality often coincide, but not always, and this isn't one of those cases. The one that's trotted out most often in relation to this duty is deterrence. I mean, that's a big one in any equitable duty, and this is one of those. So we tend to feel that there is a reason to go kind of slightly over the top so that we discourage behaviour by directors which would be perhaps proximately a problem. So we'll allow an overreach and make it really, really strict because we'll deter, if you like, unpalatable behaviour which is sort of disloyal to the functions of being a director and to the company's interests. So that's the one that you hear about most. I mean, that certainly does have value. Another one I think that's interesting that's been innovated in recent times, that Matthew Connellan has written about this, and he suggested that another link would be to say that in a way the conflicts of interest duty serves a purpose in ensuring that directors stay focused in on their main task at hand, which is to manage the company, that they don't end up sort of veering off and thinking all the time, well, how can I benefit personally? That it makes sure that they are, in a way, kept doing what they're supposed to be doing, and in a way it buttresses the duty of care and the duty to act to promote the success of the company. And I think that's quite an interesting argument. But what I'd like to move on to look at is also some other justifications. There's one more that's also the very chestnut one that you do here, is loyalty. That, you know, directors need to be loyal to the company. So by having a very strict rule, it does help to sort of ensure that they're on the straight and narrow. So that's sort of that I guess kind of chimes well with the Matthew Connellan's thesis there. So you do see loyalty mentioned quite a lot. It doesn't totally account for overreach though, because in a way you're sort of saying, well, you're not being disloyal if there's no direct claim and the company doesn't have a proximate interest. So I think we maybe need to look further beyond these micro level justifications and explore whether perhaps there is something at a more macro level beyond the immediate director-company relationship, which looks to kind of the societal impact as a whole of these type of consequences. So my question is, can we identify sort of broader instrumental purposes here? I've been thinking about whether or not you can say that this overreach phenomenon as it applies, maybe it does help to bolster the existing framework of relationships that are bedded down in the society, and it helps to ensure equilibrium and economic stability by avoiding, if you like, disrupting the apple cart by virtue of new market actors coming in and uncertainly messing with what is, I suppose, an established framework. And I do think that has added interest in this post-financial crisis time when we think of how much upheaval was caused by reckless risk-taking, etc., and how that sort of changed the whole existing economic order as well. So that does give me further food for thought. Focusing in on a couple of aspects of that in a little bit more detail. The first thing I'm interested in is the value of just having a legally certain rule, whether you like it or not. And you may not, and I don't always like it either. But it is justifiable to say that there is value commercially in having a predictable consequence, that you know this rule is going to be implied inflexibly, you know you have to disclose or else. It means there's going to be less adjudication in the courts, people know what's happening. And to my mind, that ties in rather nicely with something called indirect rule utilitarianism. So utilitarianism is something which is sort of a hybrid of moral philosophy and economics, developed in the 19th century, and is concerned with whether a particular act enhances human welfare. And later on, when we look at rules, it was considering the collective human welfare. So does something actually contribute to human happiness, essentially? when it comes to rules, indirect rule utilitarianism looks at the function of a rule and says, we're not actually interested in how the rule is applied in an individual case. So it may not work out that well for directors. Let's face it, their happiness is not augmented by this at all, because they do rather badly out of it. But we're not interested in that. We're interested in looking only at the ex ante position, not the ex post position. So the ex ante position is that we have a strict rule and we know how it applies. So in terms of the collective interest of society, rule utilitarianism will say, this is good. We know what the consequences are. We contribute to societal equilibrium. And the disclosure else idea that runs through as a refrain in the case law also backs this up, because it's preferable to the opacity of a maturing business opportunity analysis, which means you have to go maybe into court and you have to engage in lots of discussion of, does the company really have an interest, would they have, etc. You cut out all that and you have a simple rule, and it doesn't matter that the individual outcomes are worse. Ironically, even if the individual outcomes for directors are worse, the overall impact for society is better, so the argument goes. Developing that in a couple of other ways then, I would also say that this legally certain outcome, and achieved both through the rule itself and its overreach, contributes to economic stability by reducing conflict, by meaning that you won't have as much argument about things if you know how the rule works. You will have less litigation. There are transaction cost savings involved too. There are less monitoring costs for companies because they know whatever happens, they're going to have a right to recover. That's kind of set in stone in the way it works. So companies don't have as much monitoring costs, and they can get on with just doing what they need to do. When I was delving into this, I also found a couple of other people's words that would back me up a little bit helpfully here. I went back to thinking about social cohesion and how that is something that the law can contribute to. So we're looking at, I suppose, again, at the bigger picture, at macro level normative justifications. I found it helpful to think about Emile Durkheim, actually, as somebody who back in the 19th century would have said that we need to surrender individual autonomy to a certain extent to the interests of the collective. That was his view in order to achieve social cohesion, that individual agents need to actually rein themselves in somewhat and think about others. So he would have been helpful in that regard. Also, we have a legal philosopher from the early 20th century, Roscoe Pound, and he tried to explain the purpose of Roman law. And helpfully enough, I think he said that he saw the major function of Roman law as being to discourage personal ambition with the view to preserving social order. So you need to kind of keep people's ambition back in order to ensure that we keep kind of a certain amount of stability in terms of the embedded economic order that's there, and that there is a benefit to that. I would say yes. I think we can apply those to the current context. Companies, they are the lifeblood of the economy. They drive the GDP. Undoubtedly, directors, if they go off and innovate in new ways, they would possibly add to the economy, but they may do so at the expense of the certainty and of the continuing viability of individual companies. So in a way, the overreach phenomenon in the doctrine itself, it floodlights disclosure as being the only way to go. It may seem that it's over-inclusive, perhaps it is, but it does help to bed down a view that there's a structural bias in the law which prefers established commercial enterprises over the uncertainty of new market entrants. That essentially is my paper. Happy to take questions, comments from anyone in the room. Thank you.